Today's topic of ending domestic violence was chosen by Baba. Before we begin, may I request everyone to please keep their phones on silent. Today's topic of ending domestic violence was chosen specifically by Baba, keeping in mind the motto of the foundation, which is the right to choose, the power to choose and the right to excel. And it is a subject that remains very close to Baba's heart. He still continues to write articles on domestic violence and women's rights and gender justice. It was a topic which was very close to my grandmother's heart as well. And today, the issue of domestic violence, intimate partner violence, and violence in the home, which within the four corners of a bedroom or a home is very difficult to see the signs of because it is hidden so well. There is a lot of shame associated with it, and the age-old "सह लो, कुछ नहीं होता, थोड़े सालों में ठीक हो जाएगा." So in this backdrop of societal pressure and a society that is willing to change only in parts but not in others, how do we end domestic violence? We have the Protection of Women Against Domestic Violence Act, which has given certain powers of protection, orders, restraining orders from throwing a woman out of the home, of restraining the respondent, which is the husband, from alienating his property, from temporary orders of custody of the children, to monetary relief, which can be granted at the interim stage and finally at the final stage after trial. So in this light, today I'd like to first start with Justice Mukta Gupta, who is in Delhi High Court the senior most lady judge. And no better a chief guest to start on this issue. Her judgments have ranged from the applicability of Section 21, which is monetary orders, whether a husband can seek interim relief under that, prior to even the Supreme Court passing a judgment as to who is a respondent. Would a respondent include, and that is the Kusumlata judgment of Justice Gupta's, would a respondent include a woman, or would it only be a father-in-law? Would it only be a husband? And the judgment says that anyone who is in a shared household, having a domestic relationship, would be a respondent, as vis-a-vis the aggrieved person who is the complainant. Justice Gupta.
Good afternoon, everyone. While I sit here with the photograph of Justice Sunanda Bandare, there are lots and lots of memories associated with her. She was my role model into the profession, both as a lawyer and as a judge. I confess I'm nowhere near her as a judge, but yes, if anybody says, whom would you say best till now, the number one is always Justice Sunanda Bandare. When I started practice, the first lesson she taught me was, get away from your father, be independent, because you don't grow under a banyan tree. And I think that was a very important lesson. The second lesson she gave me was, even if you go for an adjournment, be ready with the brief. I think the second lesson is what made me excel in the profession. And everybody would say she's always prepared with the matter, and probably that is what gave me the recognition. I wish, and this is what I tell each newcomer, follow these two mantras, work hard, and the success is yours. Domestic violence, a very easy and a very difficult topic. Very easy because we all have become so used to seeing it that often it becomes a part of the family. People don't even realize that what is happening is domestic violence. It is actually the misuse of power by one adult in a relationship to control another using coercive methods like physical, emotional, sexual violence, insult, and economic deprivation, etc. Since predominantly domestic violence is aimed against women in any relationship, with a minuscule percentage of men experiencing the same. I don't say that they don't, they also do, but a very minuscule percentage. Laws have been enacted to protect the women from domestic violence, as in India. The definition of domestic violence is very wide, and any form of physical, emotional, mental, economic abuse falls in the said category. Cultural mores, religious practices, economic and political conditions have been some of the reasons which have initiated and perpetuated domestic violence. The prevailing thought that a woman is a weaker sex who is dependent on men for all her needs is the underlying cause of domestic violence. Despite the enactments like 498A, 304B coming in the year 1983, followed by the Protection of Women from Domestic Violence Act 2005, one does not see end to domestic violence by mere enactment. And one of the enactments, if you go into the court, nobody calls it a PWDV Act. They said Domestic Violence Act. So I always say whether it is an act to perpetuate domestic violence or to protect. So by the name itself, it has become Domestic Violence Act, DV Act, though it's protection from domestic violence. Our constitution provides for equal rights to women in all fields. And despite the directive principles under Article 39 providing right to an adequate means of livelihood for men and women equally, equal pay for equal work for both men and women, protection of health, strength of men and women children from abuse and entry into vocations unsuited to their age and strength, and Article 42 providing just and human conditions of work and maternity leave, these rights are a far cry from reality. To have a society free from domestic violence, we need to practice and imbibe amongst us the most important fundamental duty included in the Constitution by Article 51(1)(a), which imposes a fundamental duty on every citizen to renounce practices derogatory to the dignity of women. This imbibing of the fundamental duty starts from the basic unit of the society, that is our home, then to the society, the state, and the world. But let's see, in how many houses, how many households do we practice this? Take, for example, if there is a choice due to financial constraints, whom to teach, whether the girl or the boy, the choice is always the boy and not the girl. I am not talking about the 10, 15, 20% of strata which treat their daughters with equality. Probably the majority sitting over here belong to that. But when we talk about that 80 to 90% where they say, लड़की तो दूसरे घर चली जाएगी, लड़का तो अपने घर का ही है, तो सब कुछ इसी पे इन्वेस्ट करना ज़रूरी है, चाहे वो पढ़ाई में पैसा हो, चाहे प्रॉपर्टी में हो, चाहे किसी में हो. We always talk about women empowerment. But what do we understand by women empowerment? We feel that women empowerment will be an end to domestic violence. Women empowerment is not merely that the women get educated and they start earning. They get empowered when they are in the process of a decision making in the family, in the society, in the state, and in the world. Not every earning woman is an empowered woman, and not every non-working woman not an is not cannot be said to be not empowered. Many women who do not earn still have a good say in how to handle the finances of the house. They are truly the empowered women. Whereas when you deal with domestic violence cases, it is not that women who are educated and earning do not come to the courts. The reason being, the mindset still is there that she will earn. That is an additional aspect a woman has to do. But she cannot not do the other activities which she's supposed to perform, that is all the household chores, looking after everybody's requirements in the house, and still be the obedient one where she comes, gives the money to the husband, the father, and then the same is spent by them as they way. When we say women empowerment, we don't say that it gives the luxury to the women to while away with the money. But the fact is, how an investment is to be made, how it is to be effectively used, what is to be done in the house, how the household has to be carried out. These are all participative steps. And when women get roll into all these participative steps, that she becomes an empowered woman. We talk about bringing end to domestic violence in the society. But whenever there is a crisis, the worst form of violence is faced by women. We have seen the pandemic, and during that period, the domestic violence rose to enormous numbers. Every time and every day, there were a number of calls to the helpline seeking help. Women who were working, it is more women who lost their job as compared to men. And with this kind of situation, women are the first to be thrown into sexual trafficking and face all kinds of sexual abuse. The Protection of Women from Domestic Violence Act was enacted to minimize the cumbersome position of law, be it procedural or substantive, to protect the women from acts of domestic violence. The legislative intent was emphasized by the Supreme Court in Indra Sharma's case, stating that DV Act is enacted to provide a remedy in civil law for the protection of women from being victims of such relationship and to prevent the occurrence of domestic violence in the society. The objective of the Act lays down an act to provide for more effective protection of the rights of women guaranteed under the Constitution who are victims of violence of any kind occurring within the family and for matters connected therewith or incidental thereto. This act was in terms of the recommendation of CEDAW and thought that it will give lot of remedies. Yes, it did provide remedies, but yes, it has provided number of challenges. Coupled with some of our judgments, which though progressive, have further added up to the challenges. The challenge to get an interim maintenance, which initially I thought the judge from the instinct would say at least give 4, 5, 6, 10,000. Now because of the affidavits, the interim maintenance itself is taking years to be granted. What to talk about the final maintenance? Then the shared household is also a difficult aspect to be dealt with. There are cases where women continue to be living in the shared household as a tool to settle the matter. There are instances where they cannot support themselves and The allurement is we get them a house, we will pay the rent, and on that pretext, the women is taken out of the household. The rent is paid for 1 or 2 months and then abandoned. The maintenance, the other issues, now especially where the women are not working, for them to be taking care of the children, themselves, residents becomes a challenge. And many a times this delayed justice becomes in denial of justice. I would like not to elaborate on all these topics before my panelists have thrown the light based on Supreme Court decisions and of the High Court, and we will leave it to the end to discuss all these issues. I must congratulate Mr. Bhandare and his team for having taken this topic, chosen this topic, which is so important that I don't find that any family or some neighborhood, somewhere, everybody is somehow connected with it. And such open and frank discussions really pave the way for improvements in the system. Thank you very much.
May I now request Ms. Pinky Anand to give her comments.
Well, ladies and gentlemen, it's a delight to be here today, even though the subject is at times encouraging, at times discouraging. Because when, as Justice Gupta said, you call the act also domestic violence, the question is what you are, of course, talking about is prevention or alleviating the pain that comes along with the situation of domestic violence, rather than domestic violence itself. But I have a few things that I want to just flag. I am not really taking through a discourse, but I am trying to compare a time when we came across a society which didn't accept in any manner that domestic violence was wrong. So you do talk about a time prior in point of history, and I can share just a couple of episodes with you where prior to 1983, because that was the turning point of domestic violence and it becoming historically something that is recognized. And even before I go there, what I want to flag is the fact that I think women empowerment, what Justice Gupta was talking about just now, and the context, in fact, of the narrative, the Justice Surendra Bhandare Foundation, Murli, Manali, Shreya, all of us who partake of this, the fact that the narrative is out in the open is one of the most significant features. And I think law ultimately tends to go in line and online with that entire phenomenon and to make it something which is to be talked about rather than brushed under the carpet. Because generally speaking, we do tend to brush these subjects under the carpet, particularly when we are talking about matrimonial relationship, because initially it was matrimonial relationship. I'll come back to that point in a little later. But coming back to pre-1983, so you had matrimonial relationship as a kind of private space, no intrusion from the public, no interference by the state, no recognition of anything that took place within the four walls, and it being left to civil and matrimonial laws to resolve those disputes by way of divorce or other proceedings. So I remember a time I was going down to the university, and on a rickshaw somebody was beating a woman. We of course didn't know the relationship, but we stopped the car and said, "What are you doing?" He said, "Meri biwi hai, main jo marzi karu." So I mean that is the kind of society that we at least have grown up with, and some of us have, some of us of course are much younger and happily have not seen that time. And similarly, I'll talk to you about even 1983 and post, when 498A came around. So when 498A came, and there was a case just in South Delhi, one of the premier localities, wife was beaten, assaulted, physically violated, and the police was called in. This was after the acts had come into being, the sections had come into being. And the police said, "But ye kya galat hai? This is nothing wrong with this. तो husband ने मारा है तो ठीक है. It hardly come to know what to know." Today, fortunately, we are not in that frame of society. We have come to a society where we recognize 498A and 406 came in 1983 and 1986. And of course, it was linked ultimately to the major concept of dowry. I must say 498A, the criminal offense which came, linked everything to dowry. So any of the complaints which came there everything said dowry and misappropriation of dowry and giving of dowry and asking for dowry and demanding for dowry. But that was a criminal offence which came into being because ultimately you wanted to punish people who had committed an offence. The offence was done, over with and taken care of, but you punish somebody for something wrong that they had done. That wasn't enough. Now again we came across situations. We do have something called the Code of Civil Procedure. Most of us here are lawyers also, or have knowledge of law. The civil procedure does have injunctive reliefs which are available. So you can ask for injunctions, and at least I did for somebody. A couple of matters where we got civil injunctions in civil procedures prior to Domestic Violence Act of 2005, where protection was given for the woman to continue staying in the residence, not being beaten, not being thrown out, and each of these corollary situations. And why that is relevant today. So why 2005 became so historic? We did need to have a preventive law in place. Something which could prevent a woman from being made destitute, thrown out. You have similar kind of provisions in 125 CRPC, for example, for maintenance. You wanted a law which didn't necessarily entail a divorce. You didn't want to go for a divorce. You wanted to be retaining that matrimonial relationship, at the same time protecting yourself, protecting your children, and being able to survive. So you had three crucial features. One was injunctive for being thrown out because you didn't have a residence. Women, generally speaking, generally, it's a very general statement, didn't have sufficient wherewithal to have the necessary resources to be able to live on their own. That is financial, of course, dependence, and which has continued on by and large even as we speak today. So that was one of the principal features. The second feature was children, because that is another tool, coercive sometimes, to coerce the other side to actually compromise in a situation, and particularly a woman. If the child is not allowed to be detained by the mother, it's again, we're talking about a gender statement here, but it is that way. And the third ultimately is compensation or maintenance. In fact, maintenance more than compensation. You do need to survive. So each of these three features by and large form the sum and substance of the Domestic Violence Act of 2005. And I know that when it came around, we were thankful that you could have a preventive mechanism into place, because where would you go? You had one window for these reliefs. Now, of course, as Justice Gupta has said, there is some part of it which has gone down the drain to the extent of delay, down the drain to that extent. However, we are always confronted with these situations, so when we want to do, we talk about the rule of law. You want to give available for all litigants, for lawyers, for society, to give due process of law. But somewhere down this due process of law, we do have to give effective recognition to the factum of destitution or unavailability of sufficient resources for a particular gender, in this case women, to be able to sustain themselves. So that speedier justice, Justice Gupta is doing something about, and hopefully we will be able to do something more to alleviate. One of the thoughts, by the way, that was floated, I don't know how far we can carry it through, is to actually, at the first instance when an application is moved by a woman for maintenance to be granted automatically without further recourse, subject to other variations, because today's survival is the question. But I leave that open. I'm not so sure how much we can sustain this, how much it is feasible. We have a diverse society. We extend from poverty to richer, to the richest. So what is sustenance needed, how much sustenance, but definitely the factum of some sustenance being provided outright while any proceedings are taking place is a must in today's society, and we can't dispense with it and leave it for another rainy day for something to come across. So again, on the question of the applicability of Domestic Violence Act, so on a little lighter note, I do remember when we were talking about to what extent the Act extends, the 2005. Now 2005 extends to mental, financial, emotional, physical. And it includes almost the entire gamut. So I remember Mr. Soni Sarabji's comment. He said, if you call your wife fat, is that domestic violence? And possibly it is.
Fat shaming. Psychological.
Psychological. So you do have that position of extending. So there are some parts of it which can be somewhat on the lighter side. We do need to review to what extent you can allow any speech to be condemned as a psychological impact on you is quite another matter. But that is, as I said, somewhat of the lighter vein. But when we dealt with the Domestic Violence Act, we came across certain thresholds. We came across certain cultural ethos. One of them, which was mentioned in the passing by Justice Gupta, was shared household. A shared household has been an essential feature. But what do you do in a country like India? You have a house which is owned not by your husband, not possibly even by his father, maybe by his grandfather or his grandmother. and you have a situation where an entire household is living, where you have maybe 3-4 sets of hierarchies and lineages into what is there. So what is my right may be infringing on somebody else's right. What is mine to live may be denying somebody else's right to live. And particularly you have also in the same context the Senior Citizens Act and the conflict between. I'm just flagging some of these issues because it's become relevant to today's society. So you have women who are wives, you have women who are mothers. You have possibly deprivation of both at different levels. So, I mean, there has been some judicial recognition of each of these features. And an attempt has been made to try to translate that into active reality. So, right from the period of Tarna Batra, which dealt with shared household and protection almost in any circumstances, you've come to Neha Huja's series today, which kind of goes into a slightly diluted realm facing actual realities. Because you do have to deal with it. That is why they always say any kind of matrimonial law basically emerges out of a factual scenario. Law as it's understood has to be translated in the facts of the given case. To what extent there is deprivation, to what extent there is right, to what extent there is a relationship, and incidentally that is the other platform where in fact domestic violence actors work well, and I thought I would just flag that. A live-in relationship. Now the only law which recognizes live-in relationship effectively as on date, what goes further we can't say, but does happen to be the Domestic Violence Act. And that is because of the wide interpretation and the real-day realities of life. Now, the question is not of judging whether this is acceptable, not acceptable, it is there. And the question is, do women suffer because of live-in relationships? Yes, they do in similar fashions to a relationship of a marriage which is akin, or a live-in relationship which is akin. So what, in fact, the courts did from time to time is to review these issues. So much so that in Khushbu's case, which had nothing to do with live-in technically, but she had made this statement about live-in relationships in Tamil Nadu. She was prosecuted in 21 cases. I happened to plead for her at the Supreme Court and represent her there. So that time I remember when this entire discussion became rampant all over the country about the rightness and wrongness of live-in relationships. And the Supreme Court, though in a different context, said we do recognize the fact that this is existing in today's society, and where a live-in relationship is akin to a marriage, that means you have a permanent kind of relationship. It's not a one-night stand. You do have an existence such as that. You represent yourself in public as being similar to marriage or akin to marriage. In each of these situations, and Lata and other judgments, of course, came into being. In Justice Karju also in one of the judgments came with this proposition to say if you have such a relationship, protect, because the entire concept of Domestic Violence Act was protection, and therefore we had the liberty, because of the wide ambit of the Act, to provide such relationships protection within the gamut of outside marriage. Of course, we are going from one forum to another forum, and now more and more human dignities and individual liberties are being discussed across the board on various platforms and other fronts too. And as we speak, of course, the Constitution Bench is hearing on other issues. This is not to do with domestic violence, by the way, but just saying relationships. So therefore the question is, you have relationships, how do you protect them? And therefore live-in relationship itself became recognized within the Act. And what the Supreme Court said, for example, in Khushbu is to live for mutually living together by adults is not illegal under law. What is not illegal under law is lawful. So ultimately to come around to that entire circumference, and as I said, this is not an advocacy of what is right and what is wrong. This is as to what is the position and what you need to do vis-a-vis women. So Domestic Violence Act, I think, has ultimately translated itself into being an umbrella protection, though of course having its own pitfalls within the system which you need to deal with. And people who are here, I mean, Justice Gupta has been doing tremendous motions in this respect, as much as in fact the recent judgments of Justice Chandrachud and Justice Nagaratna also in most of these respects, where they've covered a lot of these territories. And the interesting part, I come back to my main theme, the narrative. The narrative today has converted itself from being a not to be discussed subject to a most discussed subject. What was not discussed yesterday has become the UN opening flagship program all over and stands as on date. What was not covered in terms of inquiries, investigations, or coming out in the front. I mean, the NCRB data we were seeing, of course they cover the criminal aspects. They don't cover domestic violence itself because it's a criminal action that is covered under NCRB. Actually covers and find about 31.8% of spousal relationships suffer at the hands of their husband or their relatives in situations such as 498 and 406. So obviously the phenomenon is unfortunately continuing to persist. Law is not the only solution, but law is a remedy, and to my mind, what I find most interesting about law is the fact that when you make a law, you recognize an existence of something which is wrong and you choose to address it, and that narrative tends to keep building up to a level where the phenomenon hopefully subsides, if not is completely eroded from the system. So this is the sociological kind of framework that we all work with, and that's why we are all here today, in fact, to discuss this subject, to see how we can take it forward and how we can socially address it to bolster up the legal provisions that are there, and for law, in fact, to support the difficulties that people have and they need to address. Thank you very much.
May I now request Ms. Arora to give her comments?
Good evening. I think before me, most of the complete things covered. So I'm going to just focus on my thoughts because the topic today was ending domestic violence. So I was wondering, it's quite an open-ended subject when we talk about ending. And first of all, domestic violence is not just confined to the aspect of providing of a residence or monetary relief or custody, but there is actual physical abuse which is also covered under the DV Act. So let's go back a bit. Way back in 1800s, women were, now this is where the domestic violence concept's coming from, and I'm narrating this because I think when we talk about ending domestic violence, we must see where its roots are. So unless and until you don't deal with the roots, you're never going to end this particular malaise that afflicts societies across the world. India is not the only part where domestic violence occurs. It happens everywhere, and countries have various datas. Going back to historical times, whether you look at Europe or you look at other jurisdictions, but then Europe was the first place to recognize it and all. So until 1920, women were, men or a husband was responsible for all actions of his wife and was answerable for the actions of his wife. So it was said that it was all right for him to beat up his wife because he has to keep her in place. That was one part. And Blackstone, William Blackstone, notes it in his records in 1800. So it was all right for a man. And the second part of it was women were essentially treated as chattels, or that they were owned by their men. So if they were owned by their men, men had a right, just like some time back, Justice Gupta said, "Meri bibi hai, main jo bhi kar lun." And this is a historical concept. So therefore, when I say ending domestic violence, let's see where the beginnings are, where the roots are. So this was recognized well before 1920 in England. And for first time when the ban or it became illegal to beat up your wife was 1920. But we took a very long time because CEDAW came about in 1994. The Beijing Convention happened in 94 and 95. Before that, you had CEDAW thereafter. But our Act on Domestic Violence came in 2005. So when we speak ending domestic violence, I think because we say it's elimination of discrimination against women, ending violence, I think the first thing for us is to start at our education. Now, I'm not speaking like a lawyer. There's a lot of law that has been said before me, but let's look where we have to go. We recognize it as an offense in the criminal side. Our act mostly covers the civil part of it. But how are you going to cover the part which comes back from a historical perspective? You cover it when you recognize the factum of its existence, which you do in law, take it down to the schools and make your sons be more responsible. So have a curriculum that teaches women what are their rights, number one, and the fact that they should stand up for their rights, and at the same time educate the young men in the school that, look, this can be an offense. So there is a need to introduce a limited legal curriculum in schools, whether it's worked on a social model, whatever it is. That's one topic. Now, I was on the aspect, I'm sorry, what's happened here? Because we are talking about ending domestic violence. I think, is that okay now?
Yeah.
Okay. So that's one part of it that I wanted to cover. The other part that I want to speak about today is the DV Act covers various aspects. It covers from physical abuse to monetary relief to protection orders, residential orders, child custody, and so on and so forth. Most of it is treated as civil, but it does cover the physical violence that takes place within the four walls of a house. Now, let's compare the two jurisdictions. US has a lot of reporting on very large segment of physical violence happening in the families, whether they are relationships or they are marriages. And the reports there say that their police is also very slow to respond, does not want to take up issues which deal with people in a matrimony or as couples. The responses are slow, and very often women suffer hugely. Maybe they are actually assaulted by their men, they suffer or they die or whatever, but the response is slow and the police does not wish to interfere. If you look at large number of complaints which are filed under the DV Act, and I can tell you this as a lawyer, but I'm not talking, I think my colleagues here may be much better than this because I look at them when they come to me at the Supreme Court level. I find a very standard form wording of the complaints. I was beaten up, I had a physical abuse, now the new trend is to add unnatural sex into it, etc. You know, the saddest part is that while eventually the relief is for maintenance, the relief is for custody, the relief is for residence, but the complaint does contain a substantial part which is not specifics very often on a physical abuse, but say that I have been abused. But I have yet to come across, and I think Justice Gupta or my colleagues here will be better people to say, have the courts really looked at this part of the physical abuse or passed judgments or addressed that physical abuse that takes place in the four corners of a house, inside the confine? I have not come across many. Maybe they have, but I in my career have not seen many. So what happens is the complaint does record that there is a physical abuse. Maybe the narrative is lacking, but I don't see a judgment what happens to take the man to task or to deal with it to its logical conclusion on a physical abuse. Now, you may give her a residence because you recognize she has a right of residence. Monetary relief, one of the biggest drawbacks in the legal position today. I'll end it very soon because I know there is a time issue here. One of the biggest issues that crosses us is we have no defined system of looking at what the matrimonial assets are, dividing them at the first instance on a rough, ready estimate, and then deal with the niceties later on. So we take a protracted time, and a woman who is in urgent need of that money, whether she claims it under a maintenance, alimony, or you call it under the DV Act, the thing is the same. She will very often, on instructions of a lawyer, not on her own, embellish her case. She will embellish it to bring in all kind of allegations, including allegations against the members of the family, everything, take the matter to a point of no return, only and only because she needs the money. So you need to evolve a better system where on parting of the couple, the wife who's not working and who does not have access to some kind of a resource to maintain herself, has the swiftest access to some minimum form which keeps a body, soul together and takes care of her children, so that she's also in a position to fight. I mean, why would she give up all the cases of physical violence only because she is not in a position to fight? By the time she's got that maintenance alimony, she has lost that stomach to take the fight forward. Therefore, ending domestic violence means recognize the physical violence, deal with the physical violence. If it needs to send the man behind the bars, so be it. Recognize the fact that a woman's not going to be able to fight till she's provided for financially in given circumstances. The laws have to be turned to the point where that first amount that comes to her is the fastest. Not like what Neha has done, I recognize that. And the last thing is, you have to recognize that there are a large number of complaints which are not true and genuine. So I have a very serious issue. Most of the time we do not want to talk about it. I believe very strongly in women's rights, but I do not believe in diluting those rights in the manner 498A has gone. Because 498A got abused so badly by filing a whole lot of false complaints, today it's no longer taken as seriously as it used to be done today 15 to 20 years back. So laws which are beneficial and really concern women's rights, they are protective about their rights, have also been taken with that seriousness to ensure that they are not diluted by means of too many false, frivolous complaints. And for that, I think the fraternity is responsible. I mean, I will completely own up as that, because I don't think women who come in a distress to their lawyers ever think about adding a lot of things. The lawyers feel that it's the fastest way to bring the family on the other side to a settlement, to a talking table where a woman will get something. So it's like a pressure that is being exerted. So if you have specific law that grant her that first part of her money, her articles, her belongings, you may have probably lesser number of false frivolous complaints. I think that's the way I looked at the topic today of ending domestic violence. And the first, I think, is to me, to my heart's very close to, because I've spoken about it on occasions when I dealt with gender equality, on other issues of equality, that I think start to teach the boys and girls in the school. I think that's very, very important. Thank you. May not be very
May I now request Mr. Banerjee to give his comments?
Good evening, everyone. Biggest difficulty is to speak after three erudite speakers. I don't think much has been left for me to hold forth on.
You know the most amongst all of us, believe me.
But I will try. The topic was very interesting, ending domestic violence, and all of us had a bit of a discussion also. Ending domestic violence is emblematic. It is, of course, an aim and endeavor of any society to finish and liquidate such a vice from the society. It is very important. However, just having that dream is not enough. And therefore, I think the topic itself is expressing the dream of a lot of right-minded people in our society, which needs to be taken heed of by law and social workers. That's, I guess, my understanding of the topic today. There was an American historian called Fukuyama, who, after the collapse of the Berlin Wall in 1992, talked of end of history. According to him, history had ended, and now it would be with end of communism. It would be now nothing but a free flow for American dominion. I don't think that he was correct, and there was no end of history. History will continue. That's one aspect of any aspect of ending something forever. It's not easy. Second, the aspect that legislation, or that you will legislate away an evil in society, itself is very difficult. It is like saying that because there is a section 302, murder will end in society. It does not. Murder. So at the end of the day, law is to bring to book whether the violator is violating civil law or criminal law, and ensure that there is accountability in society. Is the jurisprudential aspect which, in my little understanding, I would appreciate to exist. Now, having said that, the Domestic Violence Act, one of the criticism is that there is domestic violence against men also, and where is the parity? And there I was, while discussing it with my colleague, Ms. Singhal, one remarkable thing came up, that it took till 1994 to declare women's rights as human rights. Now, this is stupefying. And that is only because there was a male dominion in society running through. It cannot be any other reason. You can't be saying that women need declaration of their rights as human rights. And not in the 19th century, not in the early 20th century, but nearly in the 21st century. So it's quite appalling. Then while going through, all of us have done, I also did a bit of reading. In mid-19th century, light chastisement of women was considered to be absolutely something which men were entitled to. So the difficulty is, while domestic violence is an aspect of superior financial and physical prowess of men, and that they were the ones who were handing over rights, and slowly that has finally yielded in a more society which is going towards justness. So when you say ending domestic violence, we are also looking at a more just and fair society than what it was, say, 100 years back. So no doubt men will have to take that responsibility, and men will have to do justice, and they will have to accept that predominantly domestic violence is a problem with men inflicting it on women. There is no doubt about it. Now, secondly, the act, the name of the act, of course the history has already been, my learned friends here have already spoken about it. The history of this enactment starts from the 1970s, when CEDAW came into effect, and then Vienna, and then of course Beijing Declaration, and then within 10 years of India signing it, in 1995, in 2005 we had this enactment, came in 2002 first. But it was never called, I was just thinking about it, why was it not called Prevention of Domestic Violence Against Women Act? Why was it Protection of Women Against Domestic Violence? Why not prevention? And I think it was a humble endeavor of the legislature that they will, at best, they can protect women. They can't prevent it. So this enactment, the nomenclature itself is very interesting. A lot of things have been said, but was the Domestic Violence Act, like it's 2005, is a modern enactment. There were many enactments earlier. There was 125 existing for the longest time. Then Hindu Marriage Act has section 24, all that. There's so many other provisions. Civil law also had certain remedies, as Ms. Pinky Anand also held forth on. Was it reinvention of wheel? Was it required? And that it was a requirement under the Beijing Declaration is one thing. That India was trying to come at par with international norms, which is important. A global order with respect to women's rights has to be set. However, did it just reinvent, is it old wine in new bottle? I do not know. But one thing is for sure. Today, this enactment is I can say as a practicing lawyer, is the most used, I know I'm not using the word used with sense of responsibility, not abused, most used act in the Indian courts when it comes to assertion of women's rights. And that is because it is, as it was all rightly stated by Ms. Anand, that it's an umbrella protection. I mean, you can go there and put everything in one, which is cost effective for women. And the result is that you can ask for maintenance, you can ask for an interim temporary custody of children, you can ask for something very vital, which is, of course, in Justice Mudgal's judgment in Radhika Narangi, he had talked about right of roof for a woman, which is like she shouldn't be thrown out on the street, etc. All these things have come now into a catch-all enactment, and therefore Domestic Violence Act itself becomes very, very, I think it's, even if it is dealing with old rights, but the way it deals with it makes it a very powerful enactment which is to be seen in practical use. That as far as this enactment is concerned. So the topic doesn't talk of Domestic Violence Act, it says ending domestic violence. So of course, because this is a buzzword, we all have discussed Domestic Violence Act, but there were other enactments. The domestic violence, the first time it was enacted was in 498A, and 406 was of course through judicial creativity. It was added as a part of women's rights. However, 498A was always there, and yet it was found to be inadequate because it was a penal provision and therefore could not deal with compensation and things to right a woman practically. I mean, punishing someone is one thing, but to create that balance, this enactment was absolute requirement. Now, talking of ending domestic violence, I think the aspect is embedded even in the Domestic Violence Act, and very, very careful perusal of the provision shows from section 5 to 11 that there is an interplay envisaged between the police, the social, the society, in the sense that civil society, members of civil society, as well as the judicial, the courts, to interact in smooth tandem in order to do one single-minded thing, which is protect women's rights. Has that happened? My own understanding is that it has not. Our understanding is that the courts are doing a lot, no doubt, but whether the central government has done enough by creating good experts, because you need child psychologists, where are they? Are they empaneled? Hardly they, generally the courts have to go to get very expensive help from psychiatrists and psychologists, because they are not made part of the rules. Then you look at whether the counsellors who are attached, with due respect to all of them, whether they are up to it, because at the end of the day, registered bodies have been allowed and permitted to interact with the court process in order to embellish it and fortify it, but I don't find that kind of level of counsellors. These are practical issues. Then the police, of course, police, first question is whether police should be involved in the family. Are they in any manner sensitized in any jurisdiction with their ways and with their methodology? Generally, it would be using a very hard, a very strong arm kind of an approach which the police is want to take. But with interaction with the social workers and the courts, I'm sure they would become also very important in protection of the women from such domestic violence. But then police, I think, treats these matters as mostly as a joke. We all know it. Though it spends most of the time doing, I mean, when 498A matters, a lot of police personnel are involved in it. They do their best, they work very hard. But at the end of the day, the police process becomes coercive and it becomes extortionate, with lawyers also actively playing a bit of a negative role. So now coming to at the end, I will not, I mean, there's so many, it's a multi-headed kind of a structure when it comes to domestic violence, so many provisions, so many aspects to it. But finally coming to, this is very important for me, the role of courts. Everyone criticizes courts and what the courts are doing. There is a Tower of Babel, one judgment coming like this and one judgment going there. And we're all grappling with it every day to make sense of all this din, which is created. So multiple high courts and Supreme Court, of course, benches, larger benches and all. Having said that, two things I wanted to say. One is the role of lawyers. Now, the lawyer's role is another very powerful role, because they are the ones to whom the parties go to. Now, I find that lawyers get into formulaic kind of approach, and then, as Ms. Arora said, that there is same draft being used in 5 complaints, and you are basically doing. So at the end of the day, social welfare legislation becomes a social abusive legislation. So you fit one story of one person into another, and then you just want to use that as a Procrustean standard with everyone. The result is that the courts lose interest. And therefore the lawyers need to ask whether in these matters, it's not that they need not be professionals, but they need to ask themselves whether they need to have a bit more of conscience when dealing with family matters and not treat them just as a matter to earn a living. That is one thing. Now, abuse is happening, no doubt about it. There are POXO allegations being added in order to, and it's all to yield a quick settlement because the system doesn't move. The system doesn't move. You say, okay, I'll file a police case, I'll do this, I'm not getting maintenance, I will get the in-laws in, maybe I'll get a settlement quicker. Or nowadays, with every new provision coming in, you have POXO thrown in, you have 377 being added. Because of that is being added only because it's 10 years and life imprisonment is a part of it. So you get around state of Bihar versus Arnesh Kumar. So that because that 7 years, your 41A notice has to be given, you get out of it, you start adding 377. Now, keeping these things in mind, I guess the solution is not that abuse is happening, so women are to be blamed. Of course, lawyerly tactics will be something which will be on the dock. But most importantly, the system has to be more sensitive. The moment this entire thing which the Justice Mukta Gupta also said, that at the end of the day, if there is an instantaneous grant of maintenance without really getting into the aspect of principles of natural justice, which is so dear to lawyers and judges, that no, there has to be a hearing, it can't be a non-speaking order. But if it is apparent that a woman requires some financial help, I think the court should be empowered to give that without really getting into too much of reasoning, so that there is parity created. And what happens is, because all matrimonial matters have to be settled finally, and that is the first thing as per section 9 of the Family Courts Act. The court says, oh, you go to settle it. But the woman is without any money, she is on the road. The man, therefore, you get it is not the even playing field. So how do you do that? It has to be by a very, very quick financial equalization to that extent. Can't be done perfectly. So that needs to be done fast. Maybe all this abuse will also, it will not go away, it will come down. And finally, what I wanted to say is that the way we marry is also an issue. We have Stridhan, lots of money being given, there is dowry prohibition. 30% of the provisions in the Domestic Violence Act emanate from the entire thing of the wedding. I'm not talking about marriage. The way we commit, it's expensive. Yeah, ceremony, all these things. So we need to see whether how ostentatious we want to make it. Also, so finally, this is what I wanted to say. And the other topics, the other 2-3 topics are there. Shared household is very important. Monetary compensation is very important. Preeminence of right of residence is very important, which S. Vanitha, the Honorable Supreme Court, had already underscored it. And even if it is the Senior Citizens Act and there's competing rights, still there will be preeminence to a woman's right to shared household. All these things are happening. It's very, very exciting, this field. With that, I want to say that we are going in the right direction. We need some improvement, but I'm sure it's going to come. I am very positive.
So with that, I'd open it up to the audience for questions. Smita Kaki wants a question.
Not Smita Kaki.
Lots of questions, okay.
No, not cut.
I'm not a lawyer, so first of all, let me say that I may not use the right legal language, but I want to make three observations. The one is some senior lawyer said in a lighter tone about a wife, can the wife be called fat? She certainly cannot be called fat because body abuse is also a violent act. So I hope, and I'm saying it in front of a judge so that it's taken in your next case you take it the topic seriously, more seriously. The second one is that very often we forget that physical violence has nothing to do with money at all. The rich also do the same thing as the poor do. And the third thing is that it runs in the family. The son has seen the mother being beaten up black and blue and red. The father has seen the grandmother being handled the same way, and they think that's the best way to control a woman and the easiest way. Because we consider our husband as gods. So you can't dare a God over there. That's why. And I think that is what we have to teach along in the school to the men, to the boys, that please respect a woman, and a girl, that your husband is not the God and not the end of you. Because today's girls are all becoming economically independent. And the third thing is that I feel after listening to you that the laws make hardly any difference. The same problems are continuing all the time. So what do you do? I think we have to think, especially people who are connected with the government, that try and find out some different ways by a woman is more empowered. And the law doesn't help beyond, because as you said that lawyers also take you for a ride. Sorry.
That's good.
No, I give you the...
I think Rachna ma'am and even Meera auntie has a question. Yes, and the gentleman in the blue shirt also. Oh, lots of questions. There's one there, there's Sir here, and one there.
Should I get up and speak? Okay. So one thing I want to know is, how do we expedite the execution of the orders? And also, secondly, one of my serious concerns as far as DV Act is concerned, protection, quote unquote, that Section 31 is not taken too seriously when the protection orders are violated after they are passed by the perpetrator of the crime. So I would be very happy if, I get to learn a bit from all of you.
Should we get Miss Anand to answer? Okay. We can get Miss Anand.
So, Sudha Kaki, one of the most empowered women around, raising some of the most critical questions. No, lawyers actually are not that bad. I know that Prasenjit and Meenakshi
If you have to
led
say
me to
that
believe
you're,
that.
if you have to say that you're not bad, what does it say?
No, I was coming back to this.
You could have been better.
That's true. But having said that, what I was really coming to is this, particularly the last one that you said, Sweta. So to say this, that violence is still continuing, therefore acts make no difference, that's incorrect. Because what happens is when you have laws, then you have people coming to make complaints, those are the complaints that get recorded. Otherwise, they were never recorded. By and large, reporting and non-reporting are the critical issues. So reporting is important, brushing away under the carpet is not. And therefore, we need to address it in that light. They have made a tremendous difference. But wishing it away altogether is something that we all wish. But I'm afraid that law definitely is there because crime will remain, etc. Those kind of statements. So it really is not possible to kind of do away with that. On the other fronts of this body shaming and others, to some extent you're right, I have some reservations on that, but I'll just leave it at that. It depends how we look at it. There's always a context. Mental and psychological statements have to have a little firmer bearing for it to be sustainable as a cause of action. to go into court. But the minute you change a relationship from being a personal equation to a situation which goes to court, you change drastically. So that's all I have to say. I mean, I, however, leave the situation open and fluid to the extent of where it is. So, I mean, body shaming is another aspect. Now, body shaming should not become the subject matter of yet another law if it isn't already so. It shouldn't be so. I mean, I really think we should leave some things alone and modify it and curtail it to that extent, because you're trying to deal with a situation which is far more acute than this kind of superficial statement, which may not be good socially, but doesn't require a legal redress. That's all that I want to say there. What Rachna was asking while we are at that, and if I may address that also, is how to make this process speedier. That is in fact...
The execution.
Yeah, the process execution, you're right, and the protection. Now,
And 31.
Is protection order being executable by 31? 31 is the only criminal power under the Domestic Violence Act. And yes, to some extent you're right. Because what has to be done is, since it's the only criminal section, the idea is that you provide the protection. If violated it, then you bring it into the law, criminal domain law, so to say. So yes, the seriousness of it is something that has to be taken rather importantly, but I'm afraid at times, at least I see, I don't know if Prasanjit or others may differ with it, I don't see so many people ultimately going through to try to take this issue up at that level of Section 31. So really litigation you seem to find is more prior to the stage of Section 31 than after, but it has to be taken seriously and action taken. Definitely there is no ambiguity on that, and I think we should have some kind of further order which goes along with 31. I'll tell you why. Because 31, for example, is you violate an order, you have criminal action. If you have to have criminal action, the due process of law then kicks in. That due process of law means the entire process is diluted. So you might need to kind of put again another stretch there to provide for relief there and then. I have an order in my favor, I can't be thrown out. I am being thrown out or I have been thrown out. I go for 31. What happens? Again, another process. In the meantime, I am out. There should be some adequate provision for immediate restoration, so to say, or protection that the act would not happen, rather than only punishment. That's why in each of these situations, the importance of the Domestic Violence Act is the preventive nature of it, rather than to address what happens in the aftermath. So you constantly have to gear the act back to restoration of a situation or protection while you're there.
Smitaji, just to add to what Ms. Anand said, no, it's all on the lighter note. You said despite the enactment, there doesn't appear to be a lot of improvement. I think the answer was given by Mr. Banerjee, who said 302 murder is on the statute book, but still that doesn't mean that the murder will not be committed. The only thing is it started being recognized, and once it happens, there is a protection, there is a remedial action. Prevention, as I said, has to start from a basic unit. We generally tend to put it in the schools. Schools are secondary. You rightly said that the child sees the mother being beaten, the grandmother being beaten, it becomes a norm. So when this civilization starts at the home, that they are all at par and they will be treated at par with equal rights, equal participation, I don't think that we will need an act. So the education should start from the house. The role model is always the father, the brother, the grandfather, the grandmother, and the mother and the sister. So that basic unit we need to start our work with. Thank you.
I think Sir had a question.
Hello, I am Dr. Parveen Mutreja. I am advocate in Supreme Court, and Pinkeji knows me very well. I was seeing the photographs in the morning with the Salman Khurshid and all. So this is a very good topic. But ending domestic violence, we have to find out the root cause of the domestic violence. That is the first thing. Because if we don't find the root cause, we can't end it. And with the domestic violence, it is not happening in one society or in one age group. It is happening now in every age group. I am handling many cases as a mediator. I know this is the thing, and we have to change according to the society as well. America changed it. There is also domestic violence, but they changed it with VAWA, V-A-W-A, Violence Against Women's Act. In that case, even a husband, even a man can report against the wife. And in that case, the cases are coming down, because domestic violence is the root cause of divorce. So if both the husband and wife report, they immediately send it to the mediator, and this is called attorneys, not advocates, in attorneys in USA, and they have got advocates as a counselor. The case goes to the advocates, those advocates, and they settle the cases. It doesn't go to the police. If we send the husband or the wife or anybody beyond the bar, they will immediately be violative. And they will immediately say, okay, I want divorce. And these murders like a Shraddha and all that, these are coming up in the society because provocative language of anybody, maybe husband or maybe wife, that gives rise to the domestic violence, and this is the root cause. And this is happening, false cases like as dowry and other things are coming. Yesterday, 3-4 days back, I took 2 cases as a mediator in Supreme Court. The wife was saying, he's coming, he's earning money and all that, he does not take me to the market and all for shopping. So he said, I'm ready for that. But that is. Similarly, husband was saying, when I come back to the home, she's always busy on the mobile phone, she's always busy on the kitty, she does not take care of me. So the violations are coming up because the society is changing, equal rights are changing, so we have to end the domestic violence and find out the root cause. That is the main thing. Other countries are doing it, we should also do that. Thank you.
Thank you for your comments, sir. I think there's one comment here. हेलो, कैन आई स्पीक इन हिंदी? इज इट ऑल? ठीक। मेरे को कुछ भी सवाल नहीं है मेरा, लेकिन एक छोटी सी बात है, एक डिफरेंट प्रोस्पेक्टिव है डोमेस्टिक वायलेंस का। मैं सिर्फ वो आपके सामने 1 से 1.5 मिनट में रखना चाहूँगी। देखिए, यदि आप पर्सन विद डिसेबिलिटी है, स्पेशली क्रिपल्ड डिसेबिलिटी है, तो उस केस में डोमेस्टिक वायलेंस के चांसेस बहुत बढ़ जाते हैं। बहुत सारे एग्जाम्पल्स हैं जिसमें कि चाहे वो मेल है या फीमेल, दोनों में से यदि एक पार्टनर नॉन डिसेबल्ड है तो उसमें डोमेस्टिक वायलेंस के चांसेस, और मैंने देखा है, बहुत बड़े हैं। दूसरा, एक ही फैमिली में यदि 3 बहुएं हैं और उसमें से एक डिसेबल्ड है, उसका अपना हस्बैंड, मैं फिजिकल वायलेंस की बात नहीं कर रही, मेंटल वायलेंस की बात कर रही हूँ, उसका अपना हस्बैंड, पूरा परिवार उसके साथ वायलेंस करता है। लेकिन बाकी 2 बहुएं यदि वो नॉन डिसेबल्ड हैं, भले ही वो पढ़ी लिखी नहीं है, जॉब में नहीं है, उतनी सुंदर नहीं है, उनके साथ वायलेंस नहीं है। तो मैं सिर्फ ये कहना चाह रही हूँ कि डिसेबिलिटी जो है वो वायलेंस को बढ़ाती है कई गुना। Thank you. I think there's one question at the back. Yeah. And I think we'll keep one more question after this and we'll wrap up.
Good evening to the honorable chief guest, to the panelists, madam and sir. I'm a final year student. My name is Samira Khan, and I came here with 2 pricking questions come doubts. So when I was just reading the BEAR Act while being in the law school, now I'm doing my final year internship. So when I was reading the BEAR Act, I came across one chapter. An entire chapter is dedicated for the protection officers. Because now I have gained a few bit of experience in the courtrooms, I have realized that they aren't that diligent as we expect them to be. Because there is a perception that the law is being misused. So that is one point I wanted to make. And another question, which is I think everyone might have thought in the past 1 week, because the Supreme Court is taking on this matter. We now know that live-in relationships come under the ambit of this TV Act. There are certain sort of relations which are not between heterosexual couples, but nevertheless, I wanted to ask, can the scope of domestic violence be extended in a way that those homosexual couples who are living as partners and having the same sort of relation as that of a marriage be included into it? No. That's it. Thank you so much.
Respond to the first question.
Yeah.
Last
Protection
one.
officer.
I'll just respond to the first question.
Protection officer.
Because I think to that extent my district court, so with respect I'll just take that question up. Protection officers were given a very, very important, when the act was gazetted and it was brought into effect, it was very, very important to see that protection officers had a pivotal role, right? And in fact, there is connected to the protection officers are two provisions. One is the DIR, the Domestic Incidents Report, and the second is 30, which is that they are public servants. Huh? The two things. So they were given a very, very important position. Have they, has experience in the court lived up, has the protection officer lived up to that promise? That's one question. And the second question is whether the contemplation of such an officer was required at all. The second. The first question is my own experience, and I'm speaking for a lot of lawyers who practice. The protection officer has become, with the greatest respect, I don't mean to say that they are not required, have become supernumerary in the entire act. And they mostly are not even, the lawyers take over and they fight the case. Protection officer and the role that was contemplated is not generally, statistically I don't think it is there. So first of all, they are not being utilized that. In fact, domestic incidents report comes afterwards. Once it is filed, and after that, generally it had to precede. Thirdly, the protection officers, because of the fact that they are not generally being put to use as the statute contemplated, the protection officers have become ineffective. And I can say there are instances of abuse also. Well, that is also covered in the, they are supposed to act bona fide.
The resources are also not there.
The resources are also not there. Whether they are there or not is of course a moot question, but whether they are living up to their promise, whether either due to lack of resources or lack of integrity, is something which is wide open. So this is as far as that is concerned. Secondly, my own feeling is that protection officer essentially was not required. The lawyer, the social worker, the counselor and the court is good enough to deal with these issues.
So the second question was pertaining to the same-sex relations.
Wait for the Supreme Court.
Wait for the Supreme Court is what Justice Gupta said. I'm just saying it out loud.
So one, I know we have a lot of questions which people can raise at tea also. So we'll keep it to one question for the panel, and then when they've had some tea and coffee, you can ask them some more questions.
I don't have a question, I only have a comment.
Meera Aunty was called as a witness before she, with guilt for service, she had appeared before the Rajya Sabha Parliamentary Committee before the enactment of the DD Act. So we have an expert.
Well, I'm not going to question this erudite panel, clearly. Ma'am, you're absolutely right that after CEDAW, some of the gender just laws have come in. Because no country, every country is influenced by international customary law and the conventions. And if, as Pinky said, the narrative has changed on violence, the narrative also changed globally. When CEDAW was negotiated, violence against women was a private matter, which is why the word violence or rape is not there in the text of the CEDAW. But by 1993, there has been a paradigm shift in the way we have looked at violence against women and girls with the UN General Assembly Declaration on Elimination of Violence Against Women. So that has been reflected in this country, in India too. What I want to flag to this august audience is that across the globe now, there is an increasing momentum for a standalone treaty on violence against women and girls. Clearly, the efficacy of CEDAW has been questioned, because when violence can be a manifestation of discrimination, but it goes beyond discrimination to become a human right violation. which is why the Rapporteur on Violence Against Women and Girls, Rashida Manju, as well as Radhika Kumaraswamy, have repeatedly called for a global binding mechanism, which will be a 360-degree approach to violence against women and girls, which will be proactive as well as reactive, which will give avenues for retribution, reparation, and rehabilitation. So I just wanted to flag, and the core group of friends have already got together and are calling for signatures from across the world so that the treaty initiation process can begin, either under the UN Women or under the Human Rights Council. So I just wanted to flag that.
So I'm so sorry. I know there are hands still up, but we're completely out of time. Okay, we'll get the lady there and then ma'am here, and then the questions will have to be saved for tea and coffee.
गुड इवनिंग मैम मैम 5 मिनट थोड़ा लंबा मैटर है मैम मेरा प्लीज डीवीएड का केस चल रहा था
Sorry, we'll have to limit to question, not
No,
on
not-
personal facts, please.
मेरे को इतनी देर के बाद न्याय मिला 13 साल 5 महीने के बाद मुझे न्याय मिला हाई कोर्ट ने बाइज्जत बरी किया इतने लॉन्ग टाइम के बाद पूरी ज़िंदगी ख़राब आ गई सब कुछ ख़त्म हो गया दोबारा से ज़िंदगी शुरू करनी मुश्किल हो गई है
Actually, the process is a
So,
process at times is
मैम बहुत बड़ा मैटर है बच्चे अलग हो गए सब कुछ हो गया घर में वापस आई हूँ मेरे घर में नहीं घुसने दिया जा रहा कोई मदद करने को नहीं है नीतू मैडम जो है वो मदद कर रही हैं मुझे यहाँ लेके आई हैं पता नहीं ऊपर वाले का कुछ है या नहीं है अगर ये बात
मैम आप मेरे से बात कर लीजिए पर इधर अभी जो क्वेश्चंस हैं हम जो डिस्कशन हुआ है उस पर करेंगे
ये सारी चीज़ कोई नहीं मैम
थैंक यू
I'm not a lawyer, I'm a doctor. I want to, ask, what about the men? Because usually what I've observed is that violence occurs when they are provoked. Sometimes they are provoked and they don't know how to respond and then, they physically react. So what about the side of men? How does the law look at that? Like, for example, body shaming or, provocating or doing, you can say verbal abuse. That was my question.
See, provocation is no reason to be violent, firstly. And secondly, now, what were the circumstances in which the act took place is adequately considered when the entire evidence is laid. It is not that the courts do not consider. Either it then results in an acquittal or somewhere there is a balancing act to keep the sentence low or something. It's not that all these things are not taken into consideration. But at no cost can provocation be a ground for violence.
At this, I would thank, firstly, this very esteemed panel.
Just add up to this and say, in the courts, I think every day there is so much of provocation. At the end of the day, we would be committing violence only.
There's no...
It's a challenge to keep yourself cool.
So with that, I would...
Only one question. Why are women superior to men?
They are. That's a sentence.
Because of men like you, sir.
Men comes within the woman.
I will tell you, whenever I see the board results, the first 7 toppers are girls. And the 8 to 10 are boys. When I had the occasion to give gold medals, the 7 gold medalists were girls, and 3 were boys. So they are superior, but they don't rise as high as they should do. And that is why this seminar.
And that
You all will
the
show.
foundation.
Anyway, thank you.
Thank you so much.
So, with that, can I please invite everyone for tea and coffee outside? Thank you so much.
Yes. Always a pleasure to be close to our friends.
Obviously, close to the friends, that's the main thing.
You're talking about preparing, I remember when she did your arguments, day on day. Day on day, she was talking about you. Reported about you. Or reported rather. Thank you. Those styles, huh? Yeah. What would you be? I really enjoyed reading your submissions.
I really found that very interesting. Yeah, I know that's okay.